right, folks. If you're a regular listener to this program, you know my fear about religion corrupting our political system even more so than it already has. And there seems to be just an avalanche of religious suppression and fascism that is slowly eroding the democratic system in this country that we all supposedly think we live under. There is a new threat. Just when you think, well, what else could happen? There is a case that's going to appear before the Supreme Court coming up. And I'll get to it in a second. First of all, it's called Carson versus Macon, M-A-K-I-N, Carson versus Macon. It's about two groups of parents in, actually, I think three, in Maine, in the state of Maine. But before I get into what it's about, we're all aware at this point about this session of the Supreme Court will include abortion and gun rights cases, and those are getting much of the attention. But then there's this third overlooked case that could transform one of the most consequential areas of American law, and that is the separation of church and state. What? That's right. Now, shout out to Kimberly Whale, who is the author of the piece at The Atlantic, where I found this. She's a professor of law at the University of Baltimore, and she also is the author of a book entitled How to Read the Constitution and Why. But she put together this article from which I'm going to quote liberally. But the separation of church and state is at issue. It's one of the cases going to be heard by the Supreme Court. And if the plaintiffs win, states and municipalities could be required to use taxpayer dollars to supplement parts of private religious education that many of us would find deeply offensive, including we would have to finance through our tax dollars schools that exclude non-Christians, lesbian, gay, bi, transsexual students, or their families, and teachers who did not follow the religious bullshit to the letter. I mean, this one has snuck in. I knew we were heading for a disaster where it concerned separation of church and state, but I didn't realize it was going to present, the disaster would present in this form, a case before the Supreme Court. Now, the case, like I mentioned, Carson versus Macon, or Macon, M-A-K-I-N, it involves a challenge to the state of Maine Department of Education. Now, here's the deal. They have a situation in Maine, or circumstance in Maine, and what they do, it's their use of state tuition dollars to supplement non-sectarian schools, non-religious schools. Now, under Maine's Constitution, the way it works, the state legislature must require, quote, towns to make suitable provisions at their own expense for the support and maintenance of public schools, end quote. Now, I don't understand why that would be different from the law in most states. I mean, here in Georgia, counties are required at our expense, the county's expense, to support and maintain public schools, and they do it through property taxes. But I digress. The situation is in Maine is that more than half of that state's 260 school districts, which in Maine they call them administrative units, but more than half do not have their own public schools. It's not run on a county by county system like, for example, here in Georgia, maybe in your state too. The Maine legislature passed a statute allowing those districts that don't have public schools to either contract with established public schools, like in the town down the road 20 miles, or to contract with approved private schools in nearby districts to educate their children. Or, and this is how the law reads, quote, to pay the tuition at the public school or the approved private school of the parent's choice, end quote. So what they're saying here, who pays the tuition? Well, the state of Maine would have to pay the tuition tax dollars at the public school or the approved private school that the parent chooses. That's just the way it's set up in Maine. Now, to qualify as a so-called approved private school that would then be eligible for public money assistance to educate the kids that want to go there, the law in Maine requires that the private school be, quote, a non-sectarian school in accordance with the First Amendment of the United States Constitution, end quote. Now, the case that is going to be heard by the Supreme Court boils down to a debate over that requirement that it be non-sectarian and whether the Constitution guarantees family a sectarian or religious option. Does the Constitution, the Maine Constitution, or the federal Constitution offer up a religious option where it concerns schooling being paid for by tax dollars? Now, you with me? Okay. Now, two sets of parents are involved here. Their children live in districts that operate no public secondary school, and they selected, these two sets of parents, the private Bangor, Maine Christian school, quote, because the school's worldview aligns with their sincerely held religious beliefs and because of the school's high academic standards, end quote. And then a third family chose a school called Temple Academy for the same reasons, religion. None of the families actually sought public tuition for these schools because, quote, they allege, given the non-sectarian requirement, such a request would be futile. That's according to a decision by the Court of Appeals for the First Circuit that rejected their constitutional claims, these families' claims that they were being denied First Amendment protection. But the families, now even though the families said that they were actually seeking public tuition, they went ahead, these families, and filed their lawsuit, claiming that the state of Maine's so-called non-sectarian requirement violates a number of their constitutional rights, including the First Amendment right to the free exercise of religion. Don't ask me how this interferes with the free exercise of religion. I have no way of knowing, but this is the time to file a bullshit case like this when you have a Supreme Court stacked with religious fascists. This is a time for this kind of a suit to reach the Supreme Court. Now, they lost, these families, in the lower courts, and the Supreme Court has now taken up the case for consideration. They lost in their first appeal to a court and then the appellate court, but this is what Christian fascists do. These son of a bitches will not cease and desist until such time as they have totally trampled the First Amendment requirement of separation of church and state. They won't stop. Why should they? They're doing God's work. Now, during discovery, when this case was in the lower courts, the parties stipulated that the Bangor Christian School has a mission of, quote, instilling a biblical worldview that is completely intertwined with the curriculum and identifies the Bible as, quote, the final authority in all matters, end quote. Now, under that school, the Bangor Christian School's so-called high biblical standards, it declines to hire teachers who are gay or who, quote, identify as a gender other than on their original birth certificate, end quote. Now, the other school, Temple Academy, also offers a, quote, biblically integrated education, end quote, and will not hire gay instructors. Moreover, neither school will accept public tuition payments if doing so would require compliance with the Maine Human Rights Act. Now, that act bars discrimination in employment based on sexual orientation and gender identity. These two schools do concede that they would consider accepting public funding only if doing so would not force them to change their policy of bigotry and discrimination against LGBTQ applicants in their faculty hiring practices. Oh, yeah, we'll take public money, tax dollars, but only if we can continue our religious bullshit. Now, as a threshold matter, the court will have to decide whether these families have constitutional standing to sue in order for the Supreme Court to hear. There are going to be briefs and all sorts of pre-hearing stuff filed for the court clerks to determine whether or not this rises to the point, okay, these families have standing, so they can go ahead and sue. Their schools of choice are unwilling to participate in the funding in the first place, so a ruling in their favor would not redress any concrete injury, which is required to appear in federal court. You have to show that whatever you are, whatever you are appealing your case against has to be something that is causing you some sort of, quote, injury, end quote. Anyway, Kimberly Whale, who wrote this piece, goes on, the court could decide that the lack of an opportunity to secure religious education for their kids at the state's expense is sufficient injury to provide standing to sue. Now, if they decide that, the justices would turn to the case's merits. And here's where things could go very, very badly for civil libertarians. The text of the First Amendment, which, prohibits the government from making any law, quote, respecting the establishment of religion or prohibiting the free exercise, offers no clear answers. And by its terms in the First Amendment, it applies only to the federal government of not making law, establishing religion, or prohibiting the free expression thereof. The federal government only. But the Supreme Court extended it to the states under the 14th Amendment. Now, at the most basic level, this language means that the government cannot establish a national church, period. Of course not. In colonial times, some people were required to pay religious taxes or attend an established church or face punishment for dissent. And by 1833, according to Kimberly, no state had an established religion. Now, the First Amendment was designed to move all of us away from these kinds of oppressive religious bullshit systems. And in doing so, the First Amendment also inherently prohibited states from legislatively compelling church attendance or imposing religious taxes or dictating how a church worships and giving particular church leaders government powers. It prohibited all of that. It also forbids, the First Amendment does, a state from picking and choosing which religions are eligible for government benefits based on non-secular or faith-based reasons. Okay, so the First Amendment is pretty inclusive in its prohibitions against forced religion. I mean, why is this not clear as a bell? It was to the original court and to the appellate court, but to the Supreme Court, stacked now with Christian fascists, why it's not clear at all. Hi, Truth Seekers. Mike Malloy here. As you know, we've switched formats and are now broadcast exclusively on the Progressive Voices Network. So that means you get fewer program interruptions, no corporate commercials, and lots of profanity. But our format change also means some of our radio listeners no longer hear the program. It's been a while since I mentioned our podcasts, so you may have forgotten that there is a way to listen to this program anytime you need a good dose of screaming. Visit MikeMalloy.com and subscribe to our podcasts. As a podcast subscriber, you can download the program to your mobile device and take me with you wherever you go. And if you have a friend who needs a dose of truth-seeking, you can give a gift subscription as well. That's MikeMalloy.com, and never miss a minute of the uncensored fun and frivolity.